Hi everyone and a very warm welcome. Hope you're all having a lovely day. Well, today's topic of discussion is general exceptions under the Indian Penal Code. Now, if this video happens to be your first pick from the series of videos dedicated to the subject Indian Penal Code, then I would again suggest, like every time, to please go and watch the video on the topic Overview of Indian Penal Code, because this chapter or this session is completely focusing on the exceptions to the general rules of Indian Penal Code. So it will be extremely worth your while to first get to know those general rules in order to understand the general exceptions better. Now let us begin today's video session. Well, as the slide tells you, the first two lines very clearly tell us what is the function of IPC. It is defining crimes and it is also prescribing punishments for those crimes. Now, this video session is talking about exceptions which are mentioned under chapter 4 of the IPC from section 76 to 106. Now, what do we mean by exceptions? Well, let's look at the slide, where although all the ingredients of an offense or crime are there, but still the accused, by taking one of the prescribed exceptions, gets acquitted. So the purpose of exceptions is to exclude a person from criminal liability or help a person in escaping criminal liability even though his act fulfills all the ingredients of a crime. Moving further, why do we need exceptions? Well, now whenever it is proved beyond doubt that a crime has been committed by an individual, and as per law, when a crime is committed, the individual should be punished. Now, in order to exempt a person from such legal punishment, certain special conditions have been stipulated under the Indian Penal Code. Now, mostly these conditions have been stipulated for those individuals who commit a crime without the requisite mens rea. As we've discussed in the video on overview of the Indian Penal Code, we know that for criminal liability, act plus a guilty mind are extremely important. So in case one wants to avail the benefit of general exceptions, he has to prove the absence of mens rea. Hence, the burden of proving is obviously on the accused person under the Indian Penal Code. Let's carry on. And this slide tells us about the various categories of exceptions. We are going to be dealing with not all in this video, as we have divided general exceptions into two videos. So we are going to be dealing with the first half in this video and the second half in another video. Well, this session we are going to be discussing the following exceptions, which are mistake of fact, accident, incapability, judicial acts, and necessity. Well, let us begin by discussing the first one, that is mistake of fact. Now, section 76 of the Indian Penal Code is giving immunity for acts of person who is bound by law. Secondly, such acts are done in good faith. And thirdly, by reason of mistake of fact. And what you must remember is that mistake of law cannot be entertained as a defense or as an exception under the IPC, because it is a very well established legal principle that ignorance of law can never be entertained as an excuse. Now, let me give an example. As the slide says, a police officer firing at a mob under lawful orders will not be liable, as was held in the Shiv Mangal case, because in this case the person is not only bound by law but is also justified by law according to him or her to perform that act. The other section under the mistake of fact is section 79. It is talking about exemption from criminal liability in respect of the acts that a person feels or he believes that he was justified by law to do. Now, we are talking about a real or supposed legal obligation which is a very generic term for a legal duty, and under section 79 we are talking about a real or supposed legal justification, that is an acceptable or a sufficient excuse legally speaking. Moving ahead, the next kind of exception is accident under section 80 of the Indian Penal Code. Now let us look at the ingredients of this exception. First of all, of course, it is an act or misfortune, and it is without any criminal intent or knowledge, and whatever act that has led to an accident is there, it should be carried out in a lawful manner by utilizing all lawful means, and at the same time proper care and caution should have been exercised. Let's move ahead by citing an illustration. Now, A and B were participating in a wrestling competition. A dealt a blow upon B. As a result, B fell and was severely injured. Now, let's go back to the ingredients of accident and let us analyze this illustration. Now, in this illustration, of course, it is an act of misfortune. During a wrestling competition, we presumably rule out any intent or knowledge which is criminal in nature. Of course, a wrestling match is a lawful act, and if it is happening as per rules, then of course it comes in the category of lawful means, and whatever proper care and caution is required as per the gaming rules should have been exercised in order for our illustration to fit in the category of accident. Let's go back to the slide and let's look at the next illustration, which says a hatchet while cutting wood flies off and kills a person when there was no want of caution. Hence, this is our exception of accident. Moving further, our exception of incapability may be divided or studied under these three categories. First, we are talking about incapability due to infancy. The second kind of incapability may arise due to insanity of a person, and the third may be a result of intoxication. Let us first discuss the incapability due to infancy. Now, a child below 7 years of age is absolutely excluded from any criminal liability. That means he has absolute immunity because of the maxim of Doli Incapax. As per Doli Incapax, law presumes that a child who is below 7 years of age is incapable of forming a criminal intent. Hence, the child can never be held criminally liable. Then we're talking about the next category dealt under section 83, which is giving a qualified immunity to a child who is aged between 7 to 12 years. Now, it is qualified immunity because we will have to determine from the facts and circumstances of the case whether the child understood the nature of his act. Let's see an illustration where a 10-year-old boy picks up a knife and threatens to kill his uncle. Now, in this case, first of all, the child falls within the category that is mentioned under section 83, where his immunity as far as criminal liability is concerned is qualified by the condition whether he understands the facts and whether he understands the nature of his act. So this illustration clearly tells us that this 10-year-old boy, he picks up the knife and he very clearly knows that if he attacks his uncle with the knife, then it might lead to the death of his uncle. So in this case, he clearly knows what he is about to do and what will be the implications of that act. Moving further, insanity is another aspect which makes a person incapable of understanding the nature of his act. Section 84 deals with it, and a person is going to be exempted from criminal liability due to insanity if that insanity interferes with the person's mental faculty to the extent where, first of all, he does not understand the nature of the act that he is doing. Let's take the illustration that if a person who is suffering with insanity, he picks up a knife and he attacks a person, and if it can be proved that he does not understand that a knife is a dangerous weapon, so in the first thing he does not understand what are going to be the consequences of his act. And secondly, he also should not know that whatever act he's doing is contrary to law. So that means causing hurt, grievous hurt or death of a person is against law, or it is a wrongful act. He or she or the person who is suffering from a bout of insanity should not know in order to be able to successfully take up the defense or exception of insanity. Moving further, we're talking about the third type of incapability induced by intoxication. What is extremely important here again is that first of all, the intoxication should not be voluntary. The minute it is proved that you were intoxicated by your own choice or your own voluntary will, you will not be able to take up the defense of this exception. Again, due to this intoxication, you must not understand the nature of your act, and secondly, you must not understand that the act is contrary to law. Now, if we look at the slide, it is mentioning dementia affectatia, which means that a state of mind where your functioning of mind gets temporarily suspended, and this state of mind is a result of intoxication. Moving ahead, Section 86 says if an act is an offence only when done with a particular intent or knowledge, and such act is committed by an intoxicated person, he is liable unless he can show that he was intoxicated without his knowledge or against his will. Let's look at the maxim mentioned on this slide, which means one who sins when drunk should be punished when he is sober until and unless, as per this exception, he or she can prove that the state of drunkenness or intoxication was not a voluntary choice. Now going to shift our focus on the next exception, that is judicial acts or justifiable acts. Let's take a look at the slide. Section 77 is providing exemption for judicial acts of a judge who is first of all acting judiciously. Secondly, he is doing so in exercise of his power. Thirdly, or should be acting in good faith, and fourth, should believe that such power is given by law to him. Now, this principle completely aims at securing the independence of our judiciary, but again, let's reanalyze what are the ingredients that have to be present in order to take up this defense. First of all, it should be the judicial act of a judge. Secondly, he should be exercising his power. Thirdly, acting in good faith, and he should believe that such power has been given to him by law. Moving further, Section 78 under Judicial Act says that protection to officers who are acting under the authority of judgment or order of court of justice. So Section 78 is clearly supplementing Section 77 whenever an officer of the state is performing an act, and that act is a consequence to him acting under the authority of a judgment or an order of the court of justice. Hence again, both Section 77 and 78 are ensuring the independence of judiciary, because a judgment should not only be meted out but it should also be effectively executed. So any state officer who is involved in the execution of orders of the court, his act should also be given sufficient protection, but again, it has to be proved that he was carrying out judicial orders in good faith, and he had complete faith, and he felt that he was legally obliged to do so. Now again, the ingredient of good faith has to be present. Secondly, legality of court. There has to be a belief in it. And thirdly, protection has been designed in order to save an officer who is executing a defective or invalid order. Moving further is the exception of necessity under Section 81. If we look at the maxim on the screen and we try to read this beautifully worded maxim, it says, necessity does not know any law, and breaking the words of law is not breaking the law so long as the intent of law is not broken, and the intent of law is justice for everyone. So as long as that can be ensured, so superficially or on the face of it, even if the word of law seems broken, it will not lead a person to be criminally liable. And that is why section 81 says an act done to avoid other harm or a bigger harm. So in case a person brings down a row of huts in order to prevent the spreading of fire to a bigger locality, in that case of course harm is caused, but it is done so in order to avoid a bigger harm or bigger damage. Now this section is giving protection to the doctrine of salvation, that is, it is aiming at self-preservation. It permits a lesser evil to avoid a bigger evil, and self-preservation is the gist of the exception of necessity under section 81. Now let's see a beautiful illustration. Mother's life has to be saved over a child's in the womb. Hence this is the defense of necessity. Well, this session was on the first half of exceptions that have been mentioned under Chapter 4 of the Indian Penal Code. The rest of the half, that is, we are left with the duress, consent, communication, trifles and private defense, will be dealt with in a separate video. I hope you gained from this session and you enjoyed it. Please keep us updated and help us in improving by sending us your feedback on our website. Have a great day. Thank you very much.